Thank you for that, and thank you, Panos and Sid, for this invitation to come and discuss good faith in this context of customary international law. I have to say that I have some concerns as I begin this. I'm not using the PowerPoint, so we can just forget about that. I had some concerns as I was putting this together because good faith is very broad and very much part of interpretation, regardless of how we look at it. And I think everyone can more or less agree that good faith is a very good thing to have in interpretation. So as I was drawing down the presentation, I tried to push it into one corner, but of course we can expand it out, and I will use this as a mere introduction. In that regard, yes, also, as you've noted, this was the subject of my doctoral work, the book, and this is the first time that I've presented on good faith since my defense. So even though the book was in the process, I'm going to try not to make this a defense at the same moment.
And not to repeat a whole book.
Yes, exactly. So I had to try my best on that. I don't know, that might be complex. So with that in mind, the other complexity that I realized is every one of you in this room are legal scholars or lawyers, and every one of you has an idea of what good faith is. And I bet if I asked every single one of you to write it down, we would have a lot of different interpretations of it, but we could all probably come down to something of a small agreement on what it does actually signify. So, the title of my presentation is The Interpretation of Good Faith Performance in International Investment Law, and then I add the question, additions to justice. Now, the title in itself is even a bit circular because it's the good faith interpretation of good faith performance. It ends up being this massive circle of how do we fit this all in. So I'm going to try in this to keep it to this idea of good faith performance, but of course good faith interpretation will no doubt come into it. So I think this brings us into understanding what the role of good faith is, and of course there is this first interpretive side to it. We can see this codification in the VCLT Article 31. I've tried to pull out cases where the states involved are not parties to the VCLT to hold to our customary international law theme, but I will do my best because I think in most cases, in most decisions, regardless if they're parties to the VCLT, they use it as the guidance for what customary international law is, and the expression of customary international law. So if I don't hold enough to the theme, let me know. You can grill me afterwards, and we can try again and work it out. And so there's the interpretative side out of VCLT Article 31.1, specifically for the good faith interpretation of the treaties. This puts the obligations on the tribunal. This is all tribunal interpretation of what's happening. Then the second aspect, which I'm going to try to express more, is the behavioral side of good faith. What does that mean to respect the provisions of the treaty itself in good faith? What do we mean by what are the provisions that need to be respected in good faith? Now, this is much more clear when we have state-to-state interaction, and we allow this, the respect of the treaty obligations. It becomes more interesting, I think, in international investment law. Perhaps I'm biased, but you have the private party that's benefiting from the treaty, thereby also bound somehow in this obligation to act in good faith, but ultimately it's expressed then differently. Sometimes it comes out of then domestic contractual obligations, or it comes out of the treaty, depending on how the tribunal decides to interpret it. So the ICJ has clearly stated that good faith is a principle of international law, that it's something to be respected, and something that is required in the performance of legal obligations. In the nuclear test case, they described it as trust and confidence as part of something inherent in international cooperation. So there's one of our definitions. Maybe you can add it to your own definition. But to further understand good faith itself, it's important to remember that it's never an obligation that stands on its own. It's always combined with something else. We always have something else that's holding on to it. And the ICJ has also repeatedly affirmed this aspect of it. Now that good faith isn't something that stands on its own, but what's interesting when we start looking at some investment cases is tribunals, in some cases, some tribunals, and this does not, the complexity and the diversity of tribunal interpretation is part of what makes this most fascinating. Some tribunals have expressly and explicitly added a good faith performance element to certain treaty provisions. Now, this doesn't seem so out of line. There is a good faith performance element to them anyways. But what happens in the decisions when the tribunals expressly provide that has to be performed in good faith? Now, let's just take one example, investment, the definition of investment. A lot of times we go back to the Cellini criteria of what's an investment. So an investment is a contribution of money or assets for a certain duration with an element of risk, and somehow it develops the economic activity of the host state. This is generally what we go back to when we think of investment. But what about the tribunals that have added onto that? Now there's two additional elements, and I go to the Phoenix versus Czech Republic tribunal on this. They have added in there the compliance with laws of the host state, which actually that's included sometimes in treaty provisions, so this isn't terribly out of line, but also then that the assets must have been invested in good faith. So what happens when we've added this additional element of good faith performance to something that requires good faith anyways? So what you notice in the practice is there's two very different sides to the way that arbitral interpretation of the treaties works. You end up having some arbitrators that find very black letter, it is only these four, and some that take a more expansive view, incorporating more of this general idea of public international, maybe perhaps it expands the idea of public international law into investment law, and thereby creates something more of a connected system. I hesitate at the moment. I'm very interested in regime interaction, so I won't go too far into that, but I think it's in some ways our answer to fragmentation, and I'm going to ask this again at the end of the presentation with respect to the ongoing changes in investment law. I think we can't neglect that in any presentation about investment law at this moment. All right, so Phoenix is my first example, something perhaps we're all comfortable with. I'm going to go to another example of where a tribunal added an additional element of good faith performance. And here I'm turning to the Conocophillips versus Venezuela decision. Venezuela, of course, not party to the VCLT, so I'm bringing it into customary international law. Now, this case dealt with whether or not a lawful expropriation had taken place. And in discussing whether or not the expropriation had been lawful, the tribunal looked specifically at the issue of negotiation of the compensation. So I guess in investment arbitration, it's not always very exciting to talk about when an expropriation can actually happen, but of course they can be legal if relative factors are taken into account in addition to whether or not compensation was offered. So in this case, Venezuela had, of course, expropriated the petroleum mining. They had just imposed substantial additional taxes, and ultimately, though, in the negotiations, which was what I'm going to focus on, the tribunal decided that that Venezuela had not properly taken into account the market price, and that they had therefore not negotiated in good faith. Now, of course, bring in WikiLeaks and bring in a couple years, and of course there's additional information available, and Venezuela asked, it was it was a bifurcated case, so they decided on jurisdiction first, and then costs would only be decided later. And in this determination of whether or not this issue could be reconsidered, the tribunal, looking at the issue of whether or not it was an issue of whether or not the award itself was final, which the majority indicated that the award was final, but the dissenting arbitrator considered that the new information, the new evidence had indicated that there was actually good faith negotiation. That this element that the tribunal added on, that they considered as necessary for the compensation element of it, based on what WikiLeaks tells us, actually could be confirmed. It was an issue of confidentiality with some of the earlier, obviously, because WikiLeaks got a hold of it, it was confidential. So in the dissent, the arbitrator indicated that this had revealed that the negotiations had been done in good place, and then he further stated it reveals, once verified by the tribunal to be true, but its veracity was not contested, that it was bad faith. If it was in bad faith, it was not attributable to the respondent, but to the claimants who misled the majority by their misrepresentations, because there was this issue of confidentiality they couldn't bring out. They misrepresented it, making it seem that the negotiations had not been conducted in good faith. This brings it to an issue of differences in the way that tribunals are approaching this very issue of what is good faith, what is bad faith, how these performance elements are interacting with the obligations of the treaties themselves. And what I think is interesting about these two cases that I've mentioned, the issue of investment and then this issue of good faith negotiation and a lawful expropriation, is that in both cases you're seeing that had they decided not to add in that additional element of good faith, that might have ended quite differently. It allowed a window, if you will, to perhaps discussing something that would not necessarily have been considered, even though there maintains a good faith element to all of these interactions. By expressly adding that it must be done in good faith, it almost seems to contradict in some way the ICJ's approach that it's only an obligation in combination with another obligation, so therefore it seems that it's interacting in somewhat of a different way. Now, like everything that I'm approaching at the moment with investment arbitration, I'm trying to reconcile all of this with what it means for the reforms in investment law. And there's a certain sense that perhaps it's nothing, and this is something that only a handful of arbitrators that are interested in the public international law implications to investment arbitration are holding on to, and others taking a much more commercial arbitration standpoint to investment law aren't, so you always have this diversity of opinions when it comes to treaty interpretation. But then I think about it from the standpoint of most of what's happening in these discussions, at least in Europe, it's a structural issue of how can we make a tribunal or a standing court that will better realize, be more fair, be more transparent. But then on the other hand, we have these more constitutional issues, if you will, these right to regulate, growing concerns for environmental, human, social rights. What if, instead of completely revising this system in this multilateral way, which is, of course, wonderful to think of an idea of doing it in a multilateral way, but actually implementing that from a pragmatic perspective, I will admit I'm American, I find that very difficult to imagine the world, if you will, on board with such changes. So the question perhaps comes, how could we use these good faith performance elements to change the system in a way that balances what we see as the changes, the needed changes? Of course, it comes down to the tribunal level. But if our understanding of good faith performance is fantastic, is increasingly respecting this idea of human, social, environmental rights, how does that change the way that we interpret specific provisions? How does that change the way we look at the definition of investment? How does that change, well, not necessarily the way we can lawfully expropriate, but possibly, are there environmental aspects to such things that would then change the mechanism for this? So perhaps this is looking at a reform, not necessarily from the top level, but from the bottom level, from looking at it from the standpoint of the arbitrators in those interpreting the treaty itself. So with that, and perhaps my minute left, I will leave you, and that is my introduction into this issue. Thank you.